we don't even know how the future of the NCAA's transfer waiver rule is going to pan out. Joining us on the Heister Automotive Group hotline, Brian Murphy, WRAL Sports Investigative Reporter. Brian, thank you for taking time out of what I'm sure you are poking around on more details on this story to join us. A temporary restraining order against the NCAA's transfer waiver rules. What does that mean? We'll start at the very bottom of this one.
Yeah, the most basic thing is that this two-time transfer rule, this is the rule that got Tez Walker all caught up, is gone away, at least for the next 14 days. It's gone away, and that has ramifications for some local teams. Both NC State and ECU have basketball players that have been waiting for waivers, uncertain if those guys will play in the next 14 days. But at least according to this judge in West Virginia, and this is the lawsuit that Josh Stein, the North Carolina AG, signed on to, they will be able to play. And the NCAA has put out a statement saying they will not enforce the year in residency rule for transfers. Unclear if that means just for the next 14 days or if that means for the rest of the year, or if it means for some time longer than that.
So you brought up Josh Stein signing on to it. Like, who asked for this to happen? How the judge ruling a temporary restraining order, I'm sure they didn't just bring that up out of thin air. Who asked for it?
Yeah, so the attorneys general in 6 states, in 7 states, Ohio, West Virginia, Colorado, and North Carolina, and there's a couple other ones as well, I think New York, filed a lawsuit last week. So it got a hearing very quickly. And they basically said that the two-time transfer rule, the one that requires you to sit out or to obtain a waiver, it violates antitrust law here in the United States. And the judge had a hearing this morning. I listened to most of it. Came back about 45 minutes later and issued this ruling and said, for the next 14 days, the NCAA cannot enforce this rule. The NCAA can't punish players who play in the next 14 days, and that we'll have a larger hearing in 14 days on December 27th. And so that's how this all came down. And if you read his ruling, it seems to be pretty clear that he's going to rule against the NCAA time and time again until this case is finished. If you read the rule, he basically says this is the same as Alston, just dealing with a different matter. And as we all know, the Alston case, the NCAA lost 9-0 at the Supreme Court.
Brian Murphy, WRAL Sports Investigative Reporter, connecting with us on the Heister Automotive Group hotline. So is that what's on the line 14 days from now? Is there a world where the NCAA cannot bar NCAA athletes, college athletes, from transferring as many times as they want, wherever they want, kind of willy-nilly?
Yeah, so I just got some clarification from the NCAA, and they said that they are not going to enforce the rule for the next 14 days. So for the next 14 days, if you're one of these two-time transfers and you want to play and you play, the NCAA is not going to come back and punish you or punish the school if they eventually win this case. To your point, in 14 days, December 27th, this hearing is going to be held again. They'll argue the merits of the larger case. But if you read the temporary restraining order, I mean, the judge seems to make it clear that the NCAA cannot have these rules. They simply violate restraint of trade and other things. And so I don't know the way out for the NCAA. I mean, they just can't keep losing in court all the time. It seems to me the way out of this is collective bargaining. The NFL has rules. Major League Baseball has rules. The NBA has rules. And those rules don't get challenged in court over and over and over again by the players because the Players Association has agreed to all of these rules through collective bargaining. It seems to me that the only way to stop all these lawsuits is some form of collective bargaining.
So, I mean, as soon as I hear collective bargaining, CBA, your mind jumps right to unions. Does that mean we should be seeing a college athletes union being formed sometime soon?
I'm not a labor lawyer, although I probably should have been one to cover college athletics. My understanding, and this is just from reading, is that you don't have to have a union to collectively bargain.
Well, who are you collectively bargaining with?
Well, right. That becomes the question. I guess you don't have to recognize them as employees to collectively bargain.
Okay.
They could have some sort of union, but they wouldn't be considered employees. I mean, you're going to get into tons of labor law here.
I would imagine the first thing the collective bargaining, like whoever you're the first thing the union's going to ask for is we want to be employees, and then that's the sticking point. It's like we'll negotiate with you. Perfect. I know what's going on the table first.
Right. I mean, and I think that's why Charlie Baker, the NCAA president, proposed that rule, I think it was last week, that would create this sort of super division where players would get money from a trust, but they still wouldn't be employees. Basically, all this is the NCAA trying to head off these lawsuits. I mean, there's this lawsuit that Josh Stein's involved in. There's another one with Duke's Dwayne Carter that basically says you got to throw out all the rules about compensation. And these lawsuits are just going to continue to get filed. I don't know. I mean, the NCAA's case seems decent to me, right? Like, we're a member organization. All the members got together. We voted 32-0 or 33-0 for this rule. We put this rule in place. Everyone agreed. And now we're getting sued over it. And they lost. And they lost pretty badly if you read the ruling.
Brian Murphy, WRAL Sports Investigative Reporter. Follow him on Twitter at MurphsTurf. I want to talk about the risk here, right? Because you say for the next 14 days, the waivers, the transfer rules kind of won't be enforced, at least the two-time transfer rules. If I think one example a lot of people around here are paying attention to is Cam Woods at NC State. If he plays for the next 14 days, and then even as unlikely as you say it seems, if the NCAA wins the next hearing and he's not eligible, did he just burn a year of eligibility, or is this the wild, wild west for 14 days? Anything you do, the purge, I guess, would be a better example, where it's like anything you do in the next 14 days, you will never be charged with.
Well, I mean, you could still lose a year of eligibility. I mean, that would be redshirt rules and number of games played and stuff. What I was getting at is the NCAA is saying we're not going to enforce that rule. So if you play, we can use the Tez Walker case or if you play and then we end up winning this lawsuit that says you are not eligible, we will not penalize you for having played in that 14-day period where you were eligible. So they're saying that they're waiving that rule for the next 14 days until the next hearing. But if they eventually win this case, as unlikely as that might be, you won't be punished for what you did during that 14-day period. Now, all other rules apply. It's not quite the purge. If you exceed the number of games you're allowed to play before you redshirt or things like that, I mean, all those rules still apply. I think what the NCAA is saying is we won't come back after you for saying they have a crazy rule. I mean, this is a crazy rule that the NCAA has. It says if the courts put in a temporary restraining order or some sort of injunction and ban this rule, and you play, we can, and then we eventually win the case, we can come back after you and vacate wins or take away money, postseason money. And basically the judge was like, that rule is ridiculous. We can't have that rule. And the NCAA has in some ways agreed and said, okay, while this temporary restraining order is in place, we will not, we'll not hold that against you in the way that we could have in the past.
But I guess what I want to clarify is the 2-week window cannot be used almost as a window to get somewhere else, and then you're like, we'll use Tez Walker as the example, right? Because Tez Walker, he said he's going pro, but let's pretend with this 2-week thing, he's like, actually, I want to transfer to USC. Now I know I've already transferred very well documented a bunch of times, but if I go to USC in this 2-week period, by the time the 2-week period is up, even if the NCAA wins, I'm already at USC, and I use the window to jump there. Like, I'm good.
Yeah, that's a great question, and I don't know the exact answer to that. Okay. I would imagine what the NCAA is talking about are players who are in season right now being able to play, and I do not think they want to open Pandora's box of saying, hey, all these football players
everyone that's
who
already
are in the transfer
once.
window, like you can jump back in the transfer portal. I can certainly seek some clarification on that from the NCAA, but then you're going to end up in the same Tez Walker situation that we were before, where, hey, I transferred before this rule was actually put in place. And so if I was an agent or a parent of a Division I football player who had already transferred, I would say, hey, do not use this 14-day window to transfer again.
Just wait 14 days. And it sounds like it sounds like maybe the NCAA is prepared to not win that one.
Right, you could transfer again. There'll be another transfer window at the end of spring ball.
The transfer windows are a whole other thing. Eventually, I assume all of these rules are going to be challenged, right? There's going to be some lawsuit saying you can't have transfer windows, and then you're going to be transferring everywhere, right?
Yeah, I mean, that's what the NCAA says. Hey, we've got to be able to have some rules because, you could transfer mid-season and be playing for someone else, at the end of the season. Then you really are pro sports. If you brought everyone to a table and collectively bargained some of this stuff, you might be able to say, okay, well, you can only transfer at these times. But yeah, I mean, every rule the NCAA passes from here on out, they expect it's going to be challenged in court.
It's good time to be a lawyer.
Billable hours for the win.
There we go. Brian, we appreciate you for stopping by, and we'll keep paying attention at WRALSportsFan.com.
All right. Thanks, Tim.